Hi, y'all. It is January the 19th, 2026, and this is a court gallery special presentation. Kids, as you all know, there was no court today. It was a federal holiday, court holiday. There were some courts out there that were doing first appearances mainly. I watched a little bit of it. Nothing really stood out to me, but I have one Judge Allen from last week that I thought everybody needed to see it. Tonight sounded like a great time to pull that one out of the back pocket, and I just so happened to catch a very interesting initial appearance docket in Fulton County on Saturday, right after our live stream. So, ladies and gentlemen, we're going to review a little bit of that initial appearance docket from Fulton County with a brand new judge that I haven't seen in a while. I've never seen, actually. She actually has a tag on her little box that says attorney such and such. But I'm calling her Judge Mincy because she's officiating as the magistrate for the initial appearance docket for the weekend, the long weekend. It is Martin Luther King Day, ladies and gentlemen. There was no court. We're pulling court out of the archives, and we're getting together and we're talking about it. There's a lot of people trying to change their stories in front of these judges, and it all starts right now.
Case 25-12-99. This is the people of the state of Michigan versus George Goodwin. Let's go to the record, please.
Thank you, Your Honor. Good afternoon. Gabrielle Ezell, Assistant Prosecutor for the People.
May it please this honorable court, Michael Nichols. I'm here on behalf and with George Goodwin. Mr. Goodwin's present today, and he's to my left. We're here on a motion.
I believe that this is a motion dealing with a criminal charge against your client, and wondering about whether there was an unconstitutional arrest.
Yes, we are contesting the constitutionality of the warrantless arrest. I know that two of the officers who are here today. I've also subpoenaed a witness of a traffic crash that brought us all here.
She's present. We're going to need to come back on another day.
I don't think so, because there weren't any SFSTs.
Okay.
And so all of that testimony and cross would really not be, because that takes really, to me, the longest part.
Okay.
And the video interaction of the main officer and Mr. Goodwin is very short, 5 minutes.
Are you in agreement?
Yes, Your Honor.
All right. So you want to call your first witness?
Yes, Your Honor. Thank you. The people will call to the stand Officer Gage Brownell. I'm sorry, Deputy Gage Brownell.
Okay.
I'm gonna err on the side of caution and sequester my witness. It's Elizabeth Knight.
So we actually have witnesses in the courtroom?
Yes.
Let's please excuse them.
She just wait in the hall. Thank you.
You have witnesses in the courtroom as well?
No, Your Honor.
Assistants are behind me.
Assistants are important. Mr. Brayley still here?
No, sir.
Oh, he's on?
Yeah, he's gone. She just wanted to come and listen to the hearing.
You don't need to do it.
He wants to do the hearing. He wants to listen to the hearing.
Oh, yeah, you can listen to this if you like. Sure, absolutely.
All right, sir. Right here, fix the judge.
get you to raise your right hand. Do you swear or affirm that the information that you're going to provide to the court will be the whole truth? Please have a seat. You can lower your hand. Please state your name and spell both your first and last name.
Gage Brownell, BAGEBROWNELL.
L. Brownell?
Yes, sir.
Oh, okay. I thought it was Brown. I didn't realize it was Brownell. Have questions for Mr. Brownell?
Yes, Your Honor. Thank you. Officer Brownell, where are you currently employed?
I work for Lansing Township Police Department.
What's your current position there?
I'm a patrol officer
How long have you worked there?
since May 9th of 2024.
And in that position, what kind of training do you receive?
Our trainings vary from every single call that we deal with on the road, everything in police academy. And in this case, it does include standardized field sobriety tests, again, identifying drunk drivers and intoxicated subjects.
Thank you. Do you recall working on October 29th of 2024?
I do.
And you recall what time of day you were working?
I was on a afternoon shift. This call came out at 8:36 in the afternoon.
And on that shift, you said this call came at 8:30?
Can I ask you why you remember that?
I reviewed my report right here, so, Your Honor.
Oh, so you have a report.
Yes, Your Honor.
Fantastic.
And I don't think he's reading from it.
No, he's not.
He glanced at it, but I don't think he's reading.
Go right ahead.
Thank you. And you were, I'm sorry, did you respond to that call?
Yes.
And where did you respond to?
Do the address on the report here.
Well, you don't have to have the address, just the location.
Okay, it was in the Grossbeck neighborhood.
And when you arrived on scene, what did you observe?
There was a crash in the northeast corner of the intersection. There was a truck and a Chevy Bolt in the yard, the front yard. Had damage on them.
And can you describe, was it obvious from the damage which car had hit which?
Not initially.
And it was only the two vehicles?
Yes.
And so were there other officers on the scene with you?
Yes, Officer Evan Grunner was there as well.
Evan,
Grunner, Your Honor.
you know how to spell that?
Yeah, it's GRUNDER.
Grunder. Okay.
Might be an extra end.
And once you arrived on the scene, you saw the cars. How did you initiate your investigation?
I walked over to Evan and he pointed over to the vehicle which our defendant here today was sitting in and advised,
So he was first on scene?
yes.
Okay.
We got there within this same minute. It was just a matter of he got out of his car first. He was speaking with medics and bystanders. He was pointing to that car. So that's where I started my initial investigation, was going over to that car to see who was driving the other vehicle.
And when you approached that car, how many people were in that vehicle?
There's 3 people, 2 females, and Mr. Goodwin.
And how did you identify the driver of the vehicle involved in the crash?
I asked him who was involved. After a few seconds and asking again, Mr. Goodwin spoke up and said he was involved.
And where was Mr. Goodwin in this vehicle when you spoke to him?
He was in the back seat.
And after he identified himself as being a part of the crash, how did you proceed?
I asked him to step out. Officer Evan Grunner and I were there. Evan advised me to speak with him. He stepped out and we started talking about the crash.
And
Did he state why he was sitting in the back seat?
I don't recall his explanation.
Was the car that he was sitting in involved in the crash as well?
No.
Okay. That's what was kind of confusing.
And at this point, before you speak to Mr. Goodwin, were you able to determine who the other people were in that vehicle?
I believe that they were family members. I didn't ask for their IDs initially.
Mr. Goodwin steps out of the car. What do you do?
Began speaking with him. Initially, right off the bat, I started smelling the odor of intoxicants coming off his breath. Slow responses. Even I asked him for his ID.
Okay, so I want to back up. You said you smelled intoxicants.
Yes.
What type of intoxicant did you smell, or could you describe the odor?
The odor of intoxicants smell like intoxicants. There's nothing else that smells like those.
What does that mean? Does that alcohol? Is that pills? Is it marijuana? What is the alcohol intoxicant mean?
I'd say alcoholic beverages.
And once you said you smelled the alcoholic beverages, did you notice anything else at this point?
Yeah, his eyes were glossed over, slow to respond. Initially, he was adamant he was not at fault.
Okay. And then you said you asked for his ID. Was that provided to you?
Yes, it was.
And what did that ID confirm for you?
That he was Mr. Goodwin.
Yep. And is the person that you spoke to identified themselves as Mr. Goodwin present today? And could you just identify him by something he's wearing today?
He's wearing a tan pullover.
Thank you.
Any objection, Mr. Nichol?
No.
All right. Defendants identified for purposes of the record.
Thank you, Your Honor. And at this point, what information did you get from your conversation with Mr. Goodwin?
He was involved in a crash. I asked him if he was drinking tonight because I could smell it on his breath. He advised he had 2 bush lights an hour prior to the crash.
And did he advise you what size those 2 bush lights were?
I don't recall.
And do you recall going in asking any further follow-up details about those alcoholic beverages?
I don't recall.
And at this point, how did you proceed with your investigation?
I requested Mr. Goodwin to perform standardized field sobriety tests.
And just to clarify, what are those field sobriety tests that you're talking about?
They are trained in the academy and other trainings that will determine if someone is over a 0.08 BAC or not.
And were those field sobriety tests conducted that day?
No, they were not.
And why was that?
After speaking back and forth with Mr. Goodwin, he was refusing and not willing to take them.
And after refusing to take those tests, how did you proceed?
After further speaking with Mr. Goodwin, I placed him under arrest for OWI and escorted my vehicle.
Now, when you were speaking to him after the rejection of the field sobriety test, did you notice anything else about his behavior or his demeanor?
What made you think that you needed to administer standard field sobriety tests?
Between the odor of intox on his breath, his glossed eyes, being involved in a crash, and attempting to possibly leave the crash, he didn't speak with anyone else on scene. He walked over to a separate vehicle and didn't identify himself initially until I had to go find him. The totality of the circumstances in this case led me to believe that he was intoxicated.
So the odor, his eyes trying to leave the scene and away from the scene to begin with.
Yes.
Those are the things that you noted.
Yes.
Am I missing anything about what you noted?
I'll review my report.
Go ahead.
For the record, he's reviewing his report.
Yes, he is.
I had in my report that he was slow to respond to my questions. On top of what I've already stated.
So in your estimation, that gave you reason to do a further investigation?
Yes, Your Honor.
How did you come to that conclusion? Was that something that you came to in your own head, or was it part of your training? How did you come to believe that you needed to try and get him to do the standard field sobriety test?
All the facts that I've stated with my training experience would lead me to believe, and would also lead a reasonable person to believe that they would be intoxicated. And that is typically the next step in an investigation of operating while impaired.
So what happened next?
Once I placed Mr. Goodwin under arrest, I escorted my vehicle, search and incident to arrest. Asked him if he'd be willing to take a preliminary breath test, and he refused.
What did he say?
He advised that he was not willing. He wanted my memory, and then he wanted to talk
Would that be in your
his-
report? So that we're not guessing, just to make sure.
All right, Mr. Goodwin, his preliminary breath test rights, and he refused the PBT. Preliminary breath test.
Ms. Ezel?
Thank you, Your Honor. I just want to clarify, You mentioned that he was attempting to leave. What led you to that conclusion?
The distance from the crash to the vehicle he was in, which was running when I initially walked up to it, it didn't tell me that he was trying to be a part of the scene. My report also had that he walked past medics refusing treatment, didn't identify himself, didn't speak to anyone. He just simply walked to another vehicle, sitting in the back seat of it.
Thank you. No further questions.
Well,
Thank you. Officer Brownell, as of now, you've been a sworn police officer with Lansing Township for about 1 year and 9 months, true? As of the date of this incident, which was October 29th, 2024, you had been with Lansing Township PD for, sounds like about 6 months, true? Maybe actually not quite if we're talking May to October, right? That's 5 months, right?
Sure.
Okay. First job in law enforcement?
Yes.
Well, welcome to the profession. I'm sure you're going to have a long and prosperous, hopefully safe career, right? How many times have you testified?
It's my second time.
If you don't understand something that I ask you, just let me know, okay?
Okay.
Because sometimes, I get on a roll, you get on a roll, we're interrupting each other. I start asking questions that are compound. So just let me know. It's not a big deal, okay?
Okay.
You were trained at the academy, correct? What academy?
Michigan Police Academy. It's the LCC.
At the Mid-Michigan Police Academy, they train you on the National Highway Traffic Safety Administration, or NHTSA, standardized field sobriety tests. Also true?
True.
NHTSA SFSTs, right? So if I shorthand it as NHTSA SFSTs or just SFSTs, we're talking about what you were trained on at the academy, right?
Yes.
Okay. And there are standardized field sobriety tests, and there are also non-standardized field sobriety tests, right?
Yeah.
And there are also post-stop visual cues that you can pick up from a driver, right? There are also driving cues that you are trained to observe. Also true?
Yeah. Sure.
Yeah, I got quite a bit to cover, but the one piece I want to start with, because I didn't quite expect us to have so much emphasis on this part. You later learned that George lived right around the corner, basically, of Woodruff and Downer. True?
Sure.
And he called his wife, and his wife came to the scene, right?
I don't recall him telling me he called her.
Well, the car that he was in, you learned that that was his wife's car. She was driving. Yes?
Yes, there was a female in the front seat. I don't recall if it was this morning.
I think that was his daughter who was the passenger, right? Yes?
I do remember that. Yes.
Okay. All right. So wife comes, hey, I've just been in a crash. I mean, that's not really suspicious of anything, is it?
No.
Okay. And they were, maybe a half block away from where the crash occurred, right?
Yes.
Okay. Other people were milling about, true?
True.
Neighbors came out, hey, who's going to clean this mess up? That kind of thing.
Yeah.
Have you looked at the body worn cameras since this? You remember that older couple coming out?
Yeah. They were pressed about the damage in their front yard.
You told them this is a serious accident. They were more concerned about the garbage in the street than the condition of the people. Remember that? Yeah. I was so impressed by that moment. Anyway. Okay. So we covered that he lived right around the corner and his wife was there. And there was also somewhat of a disputation from George Goodwin to you about what caused this accident, right?
Yes.
Okay. Now, Woodruff, Woodruff is east-west, right?
Correct.
Okay. Kind of the south part of Groesbeck, right?
Yes.
Okay. And Downer is north-south, right?
Correct.
Traffic for Downer, north-south, has a stop sign at Woodruff, true?
True.
And you later learned, and if this is not correct, just tell me, you later learned, did you not, that the driver of the truck, so the other driver, ran the stop sign at Woodruff and Downer, and Mr. Goodwin's vehicle hit his vehicle. True?
I'm going to review my report.
Sure. Take your time. Just look at me when you're done.
let me stop you before you answer. Can you tell me how it is that you came to the conclusion that you're about to come to with regard to your testimony? Was it something that you decided, or was it something that somebody told you?
I looked at my follow-up with the other driver the day after. So he was not able to give his statement of the crash.
So it actually came from the other driver. It was not your conclusion.
No.
No?
Well, I don't want to get into hearsay though, Your Honor, because we do have an eyewitness here, especially.
I don't have the UD-10 with me, the crash report. So I'm just reviewing these statements in the report of the totality of the crash. How I
Well, I'm just simply asking you as you reflect back on the occurrence. Is that something that you decided, or is it something that somebody told you was the case? Did you decide that he was not at fault, or did he tell you he wasn't at fault?
I decided through my investigation that he was not at fault.
Okay.
Do you remember, and you may not have the name, but her name's Elizabeth. You remember a neighbor coming out and talking to you guys about what happened in the crash?
Yes, I do.
Okay, she's here today. Do you by chance recognize her? If you don't, that's okay. She's not in the courtroom right now. Okay. I didn't know if you saw her and said that's the lady from the scene of that case that I'm here on. You know what I mean? Okay. Now, in the NHTSA training manual, and I've got 2023 up on my MacBook. Is that the one that you were trained on if you went to the academy in 2024?
Yes.
Okay. They gave you a copy, right?
Correct.
When was the last time you read it?
Through my NHTSA manual?
Yeah.
I don't recall.
Didn't read it in anticipation of testifying?
No.
There is a section where they give you an overview of the different phases of an OWI investigation. You know what I'm talking about?
Yes.
Okay. Phase 1 being vehicle in motion,
Yes.
right? Phase 2, personal contact with the driver when you approach the driver's side window, right? Then phase 3, your SFST phase, right?
Correct.
Okay. There are, 4 basic categories of driving cues: problems in maintaining the lane, speed problems, like they're driving way too slow or speeding up and slowing down, vigilance problems, judgment problems. Those are the 4 basic categories, right?
Yes.
You don't have any evidence that any of those 4 things happened here with
Correct.
Mr. Goodwin, right?
Correct.
You didn't see him driving and nobody gave you any information that, hey, this guy was all over the road, ran the stop sign. We don't have any of that going on here.
Correct.
And we didn't have any of that going on October 29th at about 8:36 when you responded to this crash, true?
Correct.
Okay. And you covered on your testimony about what you observed with Mr. Goodwin when you were in the personal contact phase, right? Okay. You're making contact with him at the scene. And you said odor of intoxicants in your direct examination testimony. Do you remember that?
I do.
Okay. Alcohol in itself, according to your training, doesn't have an odor, right?
I agree with that.
Okay. You smell things that are consistent with the flavorings in it, right? Okay. So if he said, and I'm not going to make an issue about whether he was actually drinking Busch Light or Busch Light NA, he told you that he was drinking Busch Light, right? But the odor wouldn't tell you the difference if it was non-alcoholic or just regular Busch Light 4.8%, right?
Correct.
Okay.
Can actually kind of keep your voice up
Yeah.
because you're being recorded.
I apologize.
No problem.
Sick.
No problem.
Did you work overnight?
Last night? No.
Yeah.
I worked tonight.
Okay. You're also trained that it is important to take good notes, correct?
Correct.
And the notes that you took contemporaneous with your observations or right after help form your police report when you draft your police report, right?
Correct.
And several times your police report, I'm not saying there's anything wrong with it because this was a long time ago, but you use that to refresh your recollection on something like this, right?
Correct.
So you preserved in the report everything that you remember in terms of your important observations from that night, right?
Correct.
When was the last time you looked at the body worn camera?
I watched my initial interaction with Mr. Goodwin from the time I began the scene until I put him in handcuffs before I came into court today.
Okay. That amount of time was not even 5 minutes, right?
Correct.
You made the arrest decision before offering him the PBT as you testified on direct examination, right?
Correct.
You were going to arrest him whether he took the PBT or not.
Correct.
Give me just a moment, Mike.
Mr. Nichols.
How does that work? If you make the decision to arrest or you give the PBT, for example, you give a PBT and the PBT comes back as zeros and you had thought that you were going to arrest them, you still arrest or what do you do?
The PBT in my training experience is not brought to court on my side of things. It can only be brought into court by the defense attorney. That's what I've been trained. On top of that, it is not calibrated to the point where it is a arrest decision. My arrest decision is based off the totality of the circumstances.
So while you may not have relied on the absence of the PBT, it's just a small factor in the overall constellation of what else you're doing as part of your investigation.
Correct.
Okay. Because it almost sounds like it just cancels the entire investigation because you decide that you're going to arrest irrespective. That's not what you're saying.
Correct. I am not arresting based off just a PBT result.
This means
I'm going to go back to your training, Officer Bonnell. You recall in your training that under Michigan law, the PBT in and of itself can be sufficient evidence to make an arrest decision if there's a traffic crash and you suspect alcohol, right?
I have never done that on the street. You just simply PBT someone and arrest them.
Okay. All right. Let's go kind of through your training a little bit. Made the arrest decision based on the personal contact phase, right? Because you didn't see him driving and you didn't do SFSTs. True?
Correct.
We agree. Okay. The odor of intoxicants in and of itself, according to your training, is not enough to make an arrest decision. Also true?
True.
And the observation of, I think you said, did you say glassy or glossy about his eyes?
Except lost.
The glossed eyes, that in and of itself is not enough to make an arrest decision, right?
Just by itself, no.
Okay. It sounds like you've got slow to respond, glossed eyes, odor, and he told you, hey, an hour ago I had 2 bush lights, right?
Correct.
And that's what you based your arrest decision.
Correct.
It seemed to me in watching the body worn camera and listening that you and Evan, the other officer,
Correct.
let me call him by his last name, Grudner,
Yes.
commiserated about what to do with Mr. Goodwin. You remember that?
I don't recall it.
Okay. You don't remember him, and I don't want to ask about what he said, seriously, but you don't remember him talking with you about whether you had enough to make an arrest or should make an arrest on Mr. Goodwin?
I don't recall it. No.
Okay. All right. Your Honor, I don't believe I have anything further at this time.
thank you, Mr. Nichols. Ms. Ezel?
You just have a brief moment for a few redirect questions.
Sure, please.
Just to follow up on cross-examination, did you have the opportunity to observe Mr. Goodwin driving?
No.
And why not?
Because I responded to the crash that he drove.
Was there any other reason to believe that driving may have been impaired in this situation?
Outside of what we've already spoken to about, no.
And if a standard field sobriety test is rejected, denied, what are you trained to do?
With the facts and circumstances that might be happening during that scene that I'm on, I can make an arrest decision or not. If I believe I have enough to make an arrest for operating while intoxicated.
And if a PBT is denied, what are you trained to do?
They're subject to a $100 civil infraction fine. But again, that is not by determining that or if they're truly intoxicated or not.
And if a PBT is denied, do you end your investigation into the OWI at that point?
Well, once they read their chemical test rights, then we'd be going to the hospital with either a search warrant or not to get a blood draw to see their VAC.
So I just want to clarify, if somebody denies taking a PBT or field sobriety tests on scene, that does not end your OWI investigation.
No.
Thank you. No further questions.
All right. Thank you so much for your time.
I actually want to call him, unless Ms. Ezel is not done. I was going to call him. I had one more thing to cover when him meeting this week. He's trying to just do it now. It's
I
like,
think it's probably appropriate if you want to do that.
okay.
No objection, right?
No objection, Your Honor.
Do you remember telling Mr. Goodwin that if you don't do the SFSTs, I'm just going to put you under arrest?
Not word for word, as you stated,
Okay.
but I do remember that him and I had a back and forth on. I suggested you perform these standardized field sobriety tests, so I believe that you are intoxicated.
Do you remember, and not necessarily, I'm paraphrasing from the body worn camera, do you remember saying, I'm going to put you under arrest if we're not going to do this? Words to that effect.
I believe that if at that point I was at that arrest decision, if he wasn't willing to take those standardized field sobriety tests based off the totality of the circumstances, like we've already previously stated, if I said that, I do believe that to be true.
And that part of your exchange with him was within about 2 minutes of meeting him, right? Yes?
Approximately.
Okay. Thank you. That's all. Thanks, Your Honor.
Do you want to explore anything further?
Just one follow-up question will do. Based on that statement that you just heard from defense counsel, can you clarify again where in your investigation you were, what you had observed?
Up until that point, speaking with Mr. Goodwin, and started off trying to find him in any different vehicle, like I previously stated, which is not normal. I've taken a lot of crashes and it's not often I have to go try and find someone. My initial contact, he wasn't speaking up right away that he was involved. Stepped out. Initially, I was hit with a wave of the odor of alcoholic beverages, intoxicants, so we previously stated. His eyes were glassy, glossed over, previously stated. And through our talk, he was slow to respond. Admitted to drinking. He admitted that he was driving. I believe I had enough for operating while intoxicated.
Slow to respond, and what's the next thing that you said?
Lost on his
Now, glossy eyes, slow to respond, and then you mentioned another thing.
If I may, Your Honor, I believe he mentioned that he was driving.
oh, so that was it. And I knew that he was driving the vehicle.
Okay.
Thank you. No further questions.
Thank you very much for your testimony, sir. Appreciate it.
Thank you, Your Honor.
Yes. Further witnesses for the people?
No, Your Honor, at this time, the people rest.
That Mr. Nichols has someone he wants to call.
Yes, call Elizabeth Knighton.
You as well, ladies. Speak up good tonight.
Raise your right hand. Do you swear or affirm that the information that you'll provide to the court will be the whole truth? Have a seat. Please tell me what your name is. And spell out your first and last name.
Elizabeth Knighton.
And how do you spell your last name?
Knighthen.
Questions for Ms. Knighton?
Thank you. We're going to address October 29th of 2024. Okay. First of all, you are here pursuant to a subpoena from our office. You and I have never met before today.
Correct.
I think we talked for the first time in our lives today.
Yeah.
Okay. Do you know George Goodwin before today? At the time of this crash, October 29th, 2024, were you living kind of in the Gross Book area?
Correct.
Okay. On what street were you?
So it was right on the corner of Downer and
Woodruff? If you could, we're here for the arrest of Mr. Goodwin following a traffic crash relative to the crash occurring? Did you observe it?
Not the impact, but everything leading up to it, and then immediately,
Because you were driving yourself?
yes, I had to quickly get out of the way from a truck behind me.
Okay. And that truck was not driven by Mr. Goodwin?
Correct. Was a pickup, different driver.
Okay, tell us about that, please.
So I had just turned onto Downer from Saginaw, so it would have been a right. I was getting close to my house, and I noticed in my rear view a truck zooming up really fast behind me. And I thought, oh my goodness, they're going to smash into me. So I had a really long driveway, but I quickly got into the beginning of it. He whipped right past me. And then next thing I hear is, well, there was a stop sign right there. He whipped right past me, went through the stop sign. I glanced away for a second, and then I just hear this loud, essentially a car crashing something, just a loud noise. So I parked my car. I got out to check on everyone. The pickup truck was what I saw first. So I immediately walked down to him. His car was right on the road, but I could see he took like a sign down. He got out of the car and kind of stumbled onto me a little bit. He was a bigger dude. I'm pretty tall, but he was tall enough where I thought, I don't want him to fall on me. And immediately I said, and excuse me for saying this, but I was like, you're an idiot. You're drunk. Like, I can tell you are not sober right now. You almost just smashed into the back of me. And I did have a 3-year-old at the time. Luckily, he actually wasn't in the car with me. I had just dropped him off. But I remember calling my mom so upset because this car literally almost smashed to the back of me. So I went and looked at him. He kind of stumbled. I told him just to sit down. I went to the other car. They were more in the tree, and he was just sitting there. So I was worried that he was severely injured. So I went up
When
there.
you say he, does that mean Mr. Goodwin?
Yes, sorry,
Okay.
Mr. Goodwin.
You recognize him in the courtroom?
Yes.
Okay, thank you.
So I went to his car window and I was like, hey man, are you okay? And he's like, yeah. And I was like, all right, like, let me go get you guys some water, like some chairs. And then just all the neighbors kind of started coming out. But I remember at one point looking and seeing him, Mr. Goodwin, my
Yes.
apologies, with an officer, and they were right like in my front yard. So I went over. Oh, he was arresting him actually. So I went over and I was like, hey, I'm not trying to intervene, but like that man in the truck he caused all of this. Like, I want to give a statement because he almost smashed into me. I was livid. And he's like, okay. And I expressed to him, like, I would just kind of be quiet. Like, I kept telling the officer, like, this truck ran the red light or ran the stop sign. I immediately could tell he was belligerent, and he just started basically crying and ran into the ambulance. And I even said to that man, I was like, don't try to scoot into the ambulance to get out of this. Like, you are totally at fault for this. And I just kept reiterating that to the officer, like, please, this man just really caused a very horrific scene.
You saw a gentleman walk out of the courtroom just now in front of me. Was that the officer you're talking about, or was it a different officer? It's okay if you don't.
Yeah, I know. He was like, it was dark and he had his uniform on, but he was short. Most people are shorter than me, but I just remember him being a bit shorter than me. So yeah, I believe that was him.
Are you sure? You're not sure. I mean, if you're not
I
sure,
know.
that's fine.
Yeah,
I know, I'm not sure.
It's not a huge point.
Yeah.
It is. I don't
He
even.
was shorter than me. That's all I remember.
I don't even know why I asked you,
Yeah.
frankly. But I do want to parse out. You, I think, testified a couple times on direct examination about the truck that was behind you, running the stop sign for northbound traffic at Woodruff.
Yep.
But yet you did not see the crash itself, right?
Correct.
Okay.
I could see him blow through the stop sign, park my car, and then the loud noise.
And is your opinion also informed by the speed that he was traveling behind you?
Yes, it was fast enough that obviously I can't say he was going 40 miles, but enough where it was quickly coming into my rear view and enough for me to like quickly get into my driveway. It wasn't, you normally wouldn't rush to go get into your driveway when a car is approaching.
Understood. And that is traveling to the north from Saginaw. You made a right turn, went
Correct.
north on Woodruff.
Yep, made a right onto Downer from Saginaw. That truck also may have made a right. I don't know. There's another street right there, but he was coming up behind me, and I'm at so it's literally the corner right there where that stop sign and that intersection is.
All right. I don't believe I have anything further.
Suzelle?
Thank you. Thank you for being here today. I'm going to try to keep this really brief. I know this day probably was pretty awful to be in and to think about afterwards. So I know you said this already, you didn't see the truck go through the stop sign, correct?
I believe I did slightly out of my peripheral.
Okay. So you could see the truck, go through the stop sign through your
Correct.
peripheral,
Correct.
but you didn't see the impact in your peripheral?
I didn't see, no.
So the truck had already gone through the stop sign when you heard the crash?
I think he was in the midst of going through it, and then I heard the crash. I mean, this was in like split second, maybe.
And that's fine. I'm just trying to clarify just to make sure we get it right. And before that truck got to the intersection, did you look over at that intersection?
Well, again, it would have just kind of, here's the intersection. My driveway would have been like that. So like as I'm driving into my driveway, it would have been kind of like just in my peripheral. But I saw him zoom right past my car and blow through the stop sign. I can't adamantly say I saw him blow through the stop sign.
Thank you. Did you see any other cars?
No.
You didn't see any other cars at the stop sign?
Not until afterwards.
You
Well,
didn't see anyone
no, not at the
stop
stop
you?
sign. Sorry.
No one stopped? Okay. So you didn't see any other cars at that stop sign until after you heard the impact?
So the only car I saw going through the intersection was the truck. Then I heard the impact. Then when I got out to look, the other car was in the tree. So he would have been coming that way where it doesn't have a stop sign.
Okay. Can you say for sure which car hit which car?
I would say it would have been the truck because the truck
Right.
shouldn't have been in that spot.
Now I'm asking,
No.
Not what she asked.
Okay.
did you see which car hit which car?
No.
Did you see which car caused the impact? Without
Right.
relying on what you saw before the impact.
I can say, and this might not be answering it, but I can say the car that ran the stop sign. Let me rephrase that.
So the car that ran the stop sign, they violated the law, correct?
Right.
Thank you. Did you see any other cars there?
Not at that time.
Okay, and you did not see the impact.
No.
So you cannot say for sure the violation of running that stop sign caused that accident. Thank you. Now, I want to turn your attention to Mr. Goodwin. You said you've never seen him before today, other than the crash.
Yeah.
And you were kind enough to offer your assistance to him on the scene. When you spoke to him, I'm sure it was right after the impact, right? Do you recall how long after that impact you did get over to him?
20, 30 seconds. Not very long. Yeah.
So right after.
Yeah. Immediately checked on the truck and then immediately went in.
Okay. And at this point, he still was in his vehicle.
He was sitting there.
And did you see him exit his vehicle at all?
I do not believe so. I don't know if I physically saw him open the door, but I saw him outside of it.
So you didn't see him again until he was talking to the officer.
Correct.
Now, did you see Mr. Goodwin driving at all?
No.
Did you see Mr. Goodwin walking at all?
I want to say vaguely walking to the officer because where he was parked was right in my front yard. So.
And other than just asking him if he was okay in that initial moment, did you have a conversation with Mr. Goodwin?
Just during when the officer was there, I can't remember the exact dialogue, but I just gave a very blanket statement and just was just take it easy. What just happened was crazy. And I believe his fiance was on the way. So I just said, I can talk with her. I was just trying to help whatever I could. It's just a very expedited situation. So I just wanted him to know, just stay cool and you're in cuffs. So I know it's kind of hard, but.
You said he was in cuffs?
Handcuffs, my apologies. Yes. So it's an intense situation. And Yeah.
So at the second time you saw Mr. Goodwin was after he had already been placed under arrest?
Correct.
Do you happen to know about how much time between when you initially spoke to Mr. Goodwin when he was in his vehicle versus when you saw him arrested?
Oh. I can't say for certain, but maybe a few minutes. Yeah, because it all kind of happened fast when the police came. So.
Right. So you were going back into your home to get chairs and water, right? And by the time you were coming back out, he was under arrest?
Yeah, the chairs were actually already in my car. So I had just like looped my car around and got it all out and
Okay, thank you.
What about the water? Where did you get the water from then?
would have been my trunk. So I had like a blue for my old job, PK Companies, and then just in my trunk I had cases of water. And then
So
some
you had
neighbors
water
came
and
with
chairs in your truck, in the
Yep.
trunk of your car?
a lot in my car.
I think that's all I had for you. Thank you so much for your time.
Of course.
Mr. Nichols.
First of all, I think we're getting a little astray and maybe a little misleading, but it doesn't. You said you were interested in studying the law when we met. Okay, so it doesn't matter if somebody hits somebody else in a vehicle or gets hit. If you run a stop sign, you're at fault
Yeah.
for what happens next. But what I want to make clear is you see out of your peripheral the truck running the stop sign from northbound traffic. Stop sign on Downer. I think I was conflating Downer and Woodruff, by the way.
Yeah, I think, yeah. So
Downer's north-south, Woodruff east-west. Right?
Yes.
Okay. And when that,
I don't mean to sound rude, but if you let him say, because we're recording this, so let him ask his question and then answer. If you start talking while he's talking, kind of gets a little bit muddled for the recording.
and it's fine. It's on me, not on you. Okay. So what I want to make clear is, on cross-examination, you were asked about whether you actually saw Mr. Goodwin's vehicle crash with the truck. I think your testimony was you see out of your peripheral the truck below the stop sign for northbound traffic, and then you hear what's consistent with a crash.
Correct.
And then when you look over, you see the result of that crash.
Yes. First, I see the truck because just where my driveway is and where the house is, his car was kind of more on the other side. So really, I could just see the truck until I walked a little bit more around my house. So I just saw the truck in Downer.
And so the record is clear also from your recollection of living right there. There's no traffic stop sign for east-west traffic on Woodruff. Is that right?
Correct.
Right.
It's just on Downer.
And you first make contact with truck guy, then you go to the guy in the other car.
Correct.
Okay. Did he look like he was dazed, confused, shaken up at all?
No, very solemn, just very calm. No, I just was like, hey, are you okay? And it's like, well, like, I'm like, all right, I'll be right back.
At any point, you said his fiance was on the way.
Yeah, I think, I don't know if he had mentioned it or she had then showed up at some point, but
Did you see him use his phone to call her?
I do not recall.
Okay. Judge Allen brought up something. Just curious, because you said you had chairs and water and a bunch of stuff in your phone related to your job. What was your job at that time?
So I have been in HR for a long time. So it was HR for a property management company for affordable housing. I also have a 5-year-old, so the car's just got anything you might need while you're out and about. But yeah, it was just a company gift and just in my car.
From equipment to watch a soccer game
Yeah,
to
my kiddo was doing soccer and yeah, just stays in there.
okay. All right. And I think we covered it. October 29th, 2024 was the first time you ever laid eyes on George Goodwin.
Correct.
And
Yes.
you did not know the truck guy?
No, I did not know either.
Thank you. Nothing further.
I don't suppose that you have anything further.
No, Your Honor.
Thank you very much. Appreciate it.
I'm gonna go clean my car because
Yes.
now I feel like that's weird.
No, nobody.
If you knew what's in the trunk of my car,
Weird.
that would make you feel a lot better about your life choices. Trust me.
If I ever get stuck, I'll be prepared. Thank you, everyone.
For the witnesses for the defendant.
I need to make one decision that I want to consult with Mr. Goodwin about.
Why don't I take a little break and give you a chance to
2
speak?
minutes?
Yep.
Thanks, Your Honor.
All right, back on the record with regard to case 25-1299, People of the State of Michigan versus George Goodwin. I think we've had our arguments, and actually, you guys ready to your closings or?
Yeah, we have no further proofs. I don't think I arrested, but I rest.
You ready?
Yes, Your Honor.
Go right ahead.
Thank you, Your Honor. The case today was brought after a crash investigation back in 2024 of October. As soon as the officers arrived on scene, they noticed the cars that were in the crash, one being in the roadway, one being in a tree. Officers were
Literally in the tree,
very close.
but on the ground next to the tree, right?
Correct, Your Honor.
Okay.
With that being said, the officers did attempt to investigate that crime. They brought to the two drivers of the car, one in the ambulance, one being in a different vehicle where he was seated in the back seat. When Officer Brownell arrived on the scene, as he testified, he went over to the driver who was in the other car. He asked who was initially driving, and Mr. Goodwin was slow to respond that he was the driver, a little hesitant in the officer's eyes. After being identified, the officer noticed a few more things that indicated intoxication to him. One, the attempt to leave the scene, or at least the appearance of the attempt to flee the scene, glossy eyes, an initial smell of intoxication, as the officer described it, a wave of that smell once he stepped out of the car. And there was an admission to drinking at least 2 alcoholic beverages. It was at this point that the officer believed the circumstances of the scene led to an articulable suspicion for a continued investigation into a potential operating while intoxicated. The officer tried to further their investigation by offering standardized field sobriety tests. These were denied by Mr. Goodwin. The officer tried to explain to Mr. Goodwin that, based on his observations, based on the crash, he was likely going to be arrested if they weren't able to move forward with the investigation with the field sobriety tests. Again, those were denied. Officer Brownell did place Mr. Goodwin under arrest at this point, believing that the totality of the circumstances did show that there was a probability that driving while intoxicated or even driving while impaired had occurred. It was at this point that he did also offer a PBT test on scene, and that was also denied, even though that was after the arrest. But it was stated here today, and it is standard for our police when they're investigating, that an investigation into a crime does not end when the suspect refuses to cooperate. And Your Honor, we do believe that there was a probable cause showing today that there was a reasonable suspicion or even probable cause, to believe that crime had occurred or that arrest to take place. We even heard from a witness today who was not able to say that there was any driving issues other than a different driver. She did not observe Mr. Goodwin driving. She did not observe him long enough after the incident to determine whether he was intoxicated or not. She was with him for approximately 10, maybe 30 seconds, one of those incidents being in the presence of the officer who had already determined that the crime had been happening there, or had believed that there was probability that it had. It's also our stance, Your Honor, that even though this operating while intoxicated may not have been the cause of that crash, that simply does not matter. There was still probable cause to believe that Mr. Goodwin was driving intoxicated, even if it was not the cause of.
Well, this is simply about whether the arrest was correct.
Correct, Your Honor.
Okay.
Thank you. No further.
Let's see what Mr. Nichols has to say in the violent disagreement. Well, not violent, but strenuous disagreement.
Over the years, you've heard a lot of these, many of them from me, many of them from other lawyers. I'm not going to rehash my brief for the law. I know you know it. An important point to make on this record is, what does the record support in terms of whether or not the officer had sufficiently trustworthy information for a reasonable person, a reasonable officer, to make a decision to arrest without a warrant. I found it important to put testimony into the record about the driving because there's no evidence that Mr. Goodwin exhibited any cues of impaired driving. And
Well, that he caused the accident.
correct. And I
That's probably the strongest thing that he has going for him.
And as I, sized up this case and thought about this hearing and the testimony, I thought I would hear some pushback that, maybe George Goodwin caused the accident, but it's clear that that truck blew the stop sign. And the record wasn't really clear, but I think the facts would show you that he ran right into the path of Mr. Goodwin's vehicle. And then the witness who lives right there, she runs to the scene. She yells at the guy who tailed her and probably was the drunk driver. And then she goes to Mr. Goodwin. He seems calm, quiet. She said, "What, do you know what happened?" And, he seemed to be just trying to get his bearings. So a couple things about the officer's contact with Mr. Goodwin that I think bear discussing. The officer talked about this wave, as in what I took that to mean was when Mr. Goodwin steps out of the car, then he gets the odor of intoxicants coming at him. He didn't quantify it or characterize it as either strong or mild or faint, which we often hear from officers, at least experienced officers. So we don't have a quantification about the odor. And then likewise, something that's not in this record is that he detected slurred speech or that he observed stumbling. We have a witness who saw stumbling, but it was stumbling with the other driver, and it's Knighton. The officer on October 29th of 2024, by my math, had not even been a sworn police officer for 6 months. And to talk about, I think he was maybe trying to leave the scene. That was a factor to consider. I'm sorry for the colloquialism, but the only thing I can think of is hogwash. That is the biggest misdirect.
I think people actually wash hogs.
I hope not. I've got farm families in my ancestry, but I don't know. I just hope not, because it seems like it's a pretty,
Gross.
deleterious, activity. So this young man says, I thought he was trying to leave the scene because of, I've responded to many crashes. Okay, how many crashes in 6 months have you really responded to? And let's face it, they're probably people who are not playing nicely on the zipper merge on 127 there off Lake Lansing Road. So, at any rate, what we learn on cross-examination, and I think from Ms. Knighton, is, George calls his wife. They live right there around the corner. She comes to figure it out. And in terms of, the argument that they're making about he didn't cooperate and he refused the SFSTs, well, we heard this young officer testify about it. He had his mind made up the moment he's on the scene, because he basically admitted, yeah, I told him I was going to arrest him if he didn't take the SFSTs. I believe the officer. He was going to arrest George whether he took the SFSTs or not. And in fact, he did arrest him, even though he did not take the SFSTs. Frankly, if I had been driving home and somebody blows a stop sign at that time of night and I smack into him, I'm not going to be real happy about the cops all of a sudden investigating me because this other dude blew a stop sign. What's going on with him? Why are you focusing on me? The issue of the PBT, let's just remember that the analysis for this court as the objective determiner of whether or not there was probable cause is at the moment of arrest, and that's Beck versus Ohio and the Michigan case People versus Champion. So what matters is what's at the moment of the arrest. PBTs after the arrest decision is made. The officer said clearly, I put him in handcuffs. I then offered him, I think he may have even said chemical test rights and then PBT rights. But either way, I don't think there's any dispute that PBT is offered and declined after the arrest is made. And frankly, I don't blame Mr. Goodwin at all. So we have the very minor things that standing alone would never justify an arrest decision. And you put, I'll say basically three things together: admission and the odor, and we'll even say glossed eyes, despite the fact that his eyes were probably glossed because he'd just been in this crash. We didn't talk about the speeds, but the guy blows the stop sign. George probably didn't have a chance to slow down at all, or certainly apply his brakes at all. So I wouldn't be surprised if any glossed eyes observation was because he just maybe hit his head or was at least in a crash and shaken up. This is not condoning people driving while intoxicated or using alcohol in an inappropriate, irresponsible way. Your Honor does not grant these motions often, if ever in my memory, but I think on this record, there just isn't enough. The officer should have done more, and he didn't.
Yeah.
Your Honor, it would be a mischaracterization to say that today there was an indication that the officer was going to arrest whether or not the SFTs were done. There was no indication today that the officer was inclined to arrest if the SFTs were done and passed. There was no indication of that. In fact, the officer was trying to encourage Mr. Goodwin to do those SFTs to further his investigation to determine if this was actually an OWI. Because at this point, there was probable cause to believe there was. The officer was trying to determine whether or not that probable cause was strong, whether it was there with those SFTs. He wasn't able to do so when those are denied.
Tell me if this helps you, because one of the things that I started thinking about as a young judge, it's hard to believe that I was young at one point, that there are just a litany of things that you do that allows you to proceed to the next stage. And what you do is you don't assume that you have enough information to charge somebody with illegal behavior. You just believe that there's something that you need to investigate because you smell alcohol. You smell alcohol. It's not illegal to drink and drive. It's illegal to drink and drive if your alcohol level is over a certain level. So what he's trying to do is to determine whether that level has been reached or exceeded. But none of that actually happened because all of the initial steps in the process were turned down by the defendant.
Yes, Your Honor.
So when I look at it, it's like you're building a foundation to determine whether there is additional information to allow you to go further, And at the end of that, either you make a determination that there is not sufficient evidence to charge or that there is sufficient evidence to charge. He never got to the point of being able to say that there is sufficient evidence to charge. So basically, the law allows him to go forward with respect to charges because we can't allow people to be the arbiters of whether or not they get charged with something based upon their either refusal to cooperate or their indifference to cooperating. So in a situation like this, unless you have something further, just
I have nothing, Your Honor.
you're
Yeah.
smarter than I thought you were. Some people would keep talking. I mean, it's just unfortunate because he may not have been over the legal limit. We don't know if he was over the legal limit because he didn't allow for there to be the collection of information that would either determine that he was or wasn't. And so under the state of the law, you have the right to be able to collect the information. But if you collect the information, you're left at having to conclude probably the worst case scenario as far as the defendant is concerned, that he's under the influence. Why else would he not cooperate other than he is trying to protect himself from something that he's not certain about what he's dealing with? But under circumstances, I think that the officer was justified in what it is that he did because he said, I smelled alcohol. He was slow to respond. He had glazed eyes, and he admitted that he had been drinking. So under the circumstances, he can't really just say, okay, I'm just going to say, vamonos, have a good day.
Well, I think he could have said, what size were those beers, those Busch Lights?
Yeah.
Were they tall boys?
Yeah.
Were they shorties? Were they super Busch Lights?
Yeah, they could have been high alcohol content beers. Yeah, absolutely.
So it works both ways because he has the right to refuse. The officer has the obligation to keep asking questions.
But under the circumstances, I think that what the officer did was appropriate under my understanding of the state of the law. So I'm going to deny the motion to set aside the investigation and allow the case to proceed at this point. But certainly you have an excellent, excellent attorney. I think you probably know that already, though. Yeah, he's pretty. He's the cat's meow. But listen to Mr. Man there. He's going to give you some good advice about how to go forward with regard to this thing. But at this point, Mr. Nichols, I'm going to rule in favor of the people.
I have an order denying the motion.
Sure.
I'm also going to move for a stay so that I can take this up to the circuit court.
Sure. Absolutely. Just show that to Miss Ezell.
Can I put in the order that the stay is granted? Are you granting the stay or are you denying the stay? I'm moving.
What do we have going on? It says it's not scheduled for trial or anything, is it?
I do not believe so, no.
What do we have scheduled for the next thing on it? Does it say?
I believe this is it. I believe we do not have anything scheduled after this.
So then I would be granting him a stay to pursue. Only problem with that is I just don't know how long the circuit court's going to take. We don't even know which judge may end up with the appeal.
Well, the court rule requires me to ask the trial court for a stay. And if you deny it, then I tell the circuit court, hey, I want to stay. The trial court denied it. It's just what the court rule says.
It's just kind of crazy though, isn't it? All right, I'm going to deny your request for a stay. And that way you'll hopefully get some quicker movement out of the circuit court. But we don't actually have anything scheduled, but hopefully they'll schedule something so that we'll be able to.
So I simply wrote in the motion for a stay of proceedings for an interlocutory appeal is denied. And I'll show it to Ms. Zach.
He usually keeps it short. Mr. Nichols has done quite a few of these cases.
Frank Reynolds taught me you can't appeal what you don't have in terms of an order. Got to get it
right. Oh, is he? Do you know?
We can talk.
On that note, I want to say I'm not blind. I saw the Colin group come in. Ladies and gentlemen, thank you for joining through the Colin Members Only Monday. And this is your obligatory Colin pause. We're just finishing up with Judge Allen in this interesting OWI case. And we're about to move into Saturday first appearances with a new judge, Judge Mincy. And I think these are fairly interesting cases coming up. And it all starts right now.
Oh, really? All right. Take us off the record, please.
We're gonna go position number 2, Ms. Brancho. This is the interpreter case.
Okay. And hi, Ms. Chansey. How are you this afternoon?
I'm doing well, thank you, Your Honor.
All right. This is position 2, which is 26 CR 000361B. Hilda Brancho Parara.
Muy bien, esta es la posición 2, que es el número de caso 26 CR 000361B. La señor o señorita Hilda Brancho Parra.
All right. And Ms. Chansey, let me swear you in, please.
Yes, ma'am.
Raise your right hand for me. Do you affirm that you will interpret from Spanish to English, English to Spanish, the proceedings before the court today in the proper manner without any embellishments?
I do, Your Honor.
Okay.
Yes.
All right. Thank you.
You're welcome.
All right. And this defendant is charged with 1 count of stalking and a 2nd count of harassing communications. Retrial?
Y los cargos que tiene esta acusada es de acecho y también por emitir comunicaciones de hostigamiento.
Good morning, Judge. In regards
Good afternoon.
to defendant, no prior arrest history. If you choose to release her, pretrial recommends UJR jail, nothing further.
All right.
La acusada no tiene ningún arresto anterior. Si usted prefiere, puede ofrecer la libertad a través de los servicios previos al juicio, a quien recomienda la liberación judicial sin fianza.
All right, State.
Fiscalía.
Good afternoon, Judge.
Good afternoon.
Hope all is well.
Yeah, thank you.
This is an event that happened on January 15th of this year. Officers were dispatched to Hembry Park Terrace in reference to possible stalking charge. They did make contact with the victim in this case, who is Leonor Castro.
One moment, please. Este es un evento que ocurrió el 15 de enero de este año. Los oficiales fueron despachados al 219 Henry Park Terrace con respecto a un posible acto de hostigamiento, el cargo. Ellos se contactaron con Leonor Castro. Thank you, sir.
Yes, Judge, I'm just going to summarize the factual basis, and essentially the victim in this case did hire this defendant.
Voy a sumarizar el fundamento de hecho, pero esencialmente la víctima de este caso contrató a esta acusada.
Without getting in too deep of the facts, the victim who was later divorcing her husband, this defendant then began a relationship with the husband.
Y sin ir muy lejos con los hechos, la víctima estaba divorciándose con su esposo, o sea, de esta acusada, comenzó a tener una relación con el marido de ella.
What the state believe the facts will show is that since that time, the defendant has been surveilling the home of the victim, sending text messages that were very intimidating to the victim.
Lo que la fiscalía cree que son los hechos que serán demostrados es que la acusada ha estado custodiando, vigilando la residencia de ellos. La víctima ha estado enviando mensajes escritos y o sea, mensajes de intimidación hacia la víctima.
To the point that the victim did contact law enforcement to make them aware of such incidences, and it was several of them.
Lo que en ese punto la víctima contactó a las fuerzas del orden para avisarles sobre estos incidentes y que fueron varios.
And although the state is aware that there is no criminal history, this case still gives us cause for pause and concern given the nature of the offenses.
Y aunque este caso no es un caso penal, sin antecedentes penales, este caso nos da una fuerte causa y preocupación debido a la naturaleza del delito.
As such, the state is recommending a bond in the amount of $5,000, $2,500 on each charge, one being the stalking and the other being the harassing communications.
Entonces, la fiscalía recomienda una sentencia con fianza de $5,000, $2,500 por cada cargo de acecho y hostigamiento.
The state is recommending that the defendant undergoes a mental health evaluation and treatment if necessary.
Y también la fiscalía recomienda que la acusada se someta a una evaluación de estado mental y tratamiento si es necesario.
That the defendant stay completely away from the address that I gave and have no further contact with the victim or alleged, in this case, Miss Leonor Castro.
y no tener contacto alguno con la víctima alegada, en este caso Leonor Castro,
And no alcohol, drugs, or illegal weapons while out on bond. Thank you,
y,
Judge.
y que se prohíbe el uso de drogas, alcohol y armas. Gracias, su señoría.
All right. Mr. Bartels?
Señor
Yes,
Bartelo.
thank you, Your Honor. I have spoken with Ms. Brancho with the assistance of the phone interpreter.
Yo he hablado con la señora Brancho con la asistencia de un intérprete por teléfono.
I'm advised that she is no longer employed by Ms. Castro or has any other type of relationship with Ms. Castro.
Y le he recomendado que ella no está, y avisado que no está más empleada por la señora Castro y ni que tenga ningún tipo de relación con la señora Castro.
We would submit that, well, based on what's in the warrant, I think the contents of these text messages are ambiguous. It could be argued a number of different ways.
También sostenemos que basado en la orden de arresto, el contenido de los mensajes enviados son ambiguos y podrían ser debatidos en un número de formas diferentes.
And however, because we are here, Ms. Brancho certainly is clear and understands that Ms. Castro doesn't want any contact with her, and she does not want any contact with Ms. Castro either.
Y debido a que estamos aquí, ella entiende, la señora Brancho entiende que la señora Castro no quiere tener ningún tipo de contacto con ella, ni ella quiere tenerlo con la señora Castro.
And regarding Bond, as the court has heard, it appears that she has no history at all.
Y debido a que no tiene antecedentes penales para considerar la fianza,
I am advised that she does not live at this address. I'm told that Ms. Brancho lives in Suwannee.
se me ha informado que la acusada no vive en esta residencia. Ella vive en Suwannee.
And it looks like Ms. Castro lives in Roswell.
Parece que la señora Castro vive en Roswell.
And I am advised that Ms. Brancho has been in Georgia over a year.
Y se me dijo que la señora Brancho vive en Georgia desde hace un año.
And she is currently employed at City Light Electric Company.
Y que está empleada en la compañía City Light Electric Company.
And given all of that, we would ask that she be allowed to sign her own bond and would certainly not have a problem with a no further contact and stay away.
Y por eso solicitamos que ella pueda firmar su propia fianza y no tenemos problema con la orden de no tener ningún contacto de ningún tipo.
And nothing further for now, Your Honor.
Nada más por ahora, su señoría.
Judge, I would ask that we sound for the victim, and that is the victim in this case, who is Miss Leonor Castro.
Señora Leonor Castro, si está presente en la plataforma de Zoom, avísenos, prenda su micrófono y su cámara, por favor, en este momento, ahora.
All right. Not hearing the victim, we'll move forward. with the-
Al no escuchar la presencia de la víctima, continuamos.
All right. State, are you recommending, or are you against the signature bond, or would you like for pretrial to monitor?
La fiscalía solicita la firma, la fianza bajo firma y con la oficina de servicios anteriores al juicio que monitoree a esta acusada.
Thank you, Judge. The state would be fine with pretrial monitoring at level 3, and specifically if Your Honor is inclined to have that mental health evaluation is done.
Sí, la fiscalía está de acuerdo que los servicios previos al juicio monitoreen a la acusada en un nivel 3, dado que su señoría tiene la inclinación de que se haga esa evaluación psicológica.
Mr. Bartels, did you have any indication of any inmate issues when you interviewed the defendant?
I
Señor
did not.
Bartel, ¿usted tuvo alguna indicación de algún problema en el momento que entrevistó a la acusada?
I did not, Your Honor. I'm not sure what the basis of that request is. I did not get any indication that Ms. Broncho had any difficulty understanding what was going on or what her options were.
And Your Honor,
No estoy seguro de por qué se puso ese requisito. No vi ninguna indicación que dijera que la señora Broncho tiene alguna dificultad en entender lo que está sucediendo y cuáles son sus opciones.
Your Honor, I would just add that the basis is the nature of the unwarranted and creepy surveillance, as well as the messages that had been sent to this particular victim that were intimidating and threatening in nature.
Su señoría, yo quisiera agregar que la base es la naturaleza de los cargos por su indeseable y horrible custodia o vigilancia, al igual que los mensajes que ella envió a esta víctima en particular, que fueron intimidantes y amenazantes en su naturaleza.
I will not order an MH eval at this time. I'm going to order the $5,000 signature bond, and I will order that signature bond through the pretrial services with a level 3.
Sorry. Yo no voy a ordenar una evaluación de salud mental en este momento, pero sí ordeno una fianza de $5,000 bajo firma y la ordeno para que se realice a través de los servicios previos al juicio en el nivel 3.
All right, and that's $2,500 on each of the charges. I'm going to also order a stay away from no further contact with the victim, Leonora Castro.
No tener ningún contacto de ningún tipo con Leonor Castro, la víctima.
And no drugs, alcohol, weapons, or guns while on bond.
Y queda prohibido el uso de drogas, alcohol y armas mientras esté libre bajo fianza.
All right, anything else, counsel?
¿Algo más?
Nothing further. Thank you, Your Honor.
All right,
Nada
Nothing
más.
from the state.
Gracias.
Thank you, Judge. Appreciate it.
Nada de la fiscalía, gracias.
All right. This is 26 CR 0000365E. Marcus Faust, charged with 1 count of simple battery, family violence. Pretrial.
Just a second, Judge. Let me pull that one up. Faust. Judge, in regards to Mr. Faust, 13 cycles, 4 FTAs, 22, 22, 21, and 19. Probation Chatham for aggravated assault, 2 counts, carrying a weapon in a school safety zone from 10/19/18. It was a first offender that was revoked. Resentenced to 12 years. He's on probation out of Clayton for cruelty first, criminal trespass, and simple battery, sentenced in 23. 2 years confinement, 10 years probation. His last arrest was out of Clayton, a simple battery that was dismissed in 23. Nothing further.
All right.
Excuse me, well, what position is this?
Number 8.
Number 8. Okay, thank you.
Mhm.
Yes, Your Honor. This is a incident that occurred January 16th of this year at South Fulton, and involved the victim in this case, who at the time of this incident was in fact with child. given what you've heard as it relates to the criminal history in this case, many of those cycles, Your Honor, I'm showing a total of over 20 cycles. Many of them were violent in nature. There were several FTAs, current probation. We are recommending a good bond in the amount of $2,500. We are asking that at this time that he has no further contact with the victim in this particular case, who is Miss Dominique Wilson, and that he will stay away from the incident location of South Fulton, Georgia. This is an incident that alleges that at the time of this attack, she was in fact, as I said earlier, with child. It gives us some cause for concern. So we are asking that he undergo the 24-week of family violence intervention program, at least get it started. And that is the state's recommendation, Your Honor. Thank you.
Mm-hmm.
Yes, thank you, Your Honor. I have spoken with Mr. Faust. He wants the court to know, well, he did call the police. He denies putting his hands on Ms. Black. I think it's Blackshear Wilson. I think it's Wilson Blackshear. Yes, a compound last name. He did indicate that she did take his keys from him. That's why he called the police. He indicates that there is a video available that can substantiate his side of the story. However, I advised him that that will come into play on down the road. He was born in Atlanta, Your Honor. He's lived here all of his life. His parents and his siblings and extended family live in Atlanta. I'm advised that he's employed part-time as a mover, and he also goes to UEI trade school where he is studying auto mechanics. So he has ties to the community. He is wanting to ask the court for a signature bond if he qualifies. If he does not qualify, we would ask for a $1,500 good bond, and nothing further at this time.
All right. Given his extensive history in FTAs, I'm going to order the $2,500 surety bond. Stay away from the incident location, Wolf Downs in South Fulton. No further contact with the victim, Dominique Wilson. And no drugs, alcohol, and weapons while on bond.
All right, thank you, Your Honor.
Uh-huh.
Oh, that amount was $100?
No, 2,500.
Oh,
Victim said she do. The victim said she want to do the no violence. She didn't want to do the no contact.
No further violent contact.
Yes. Well, I'm saying why I can't go there though. That's my baby mom. She pregnant. I'm the only one that paid the bills.
Well, but you had an incident, so I've ordered you to stay away, find somewhere else to live. If you need a one-time escort to get some personal items, I will do that. But you
And just
cannot.
run over.
Yes.
I'm sorry, Your Honor. I didn't mean to interrupt.
Hold on. There's somebody else is talking who doesn't have permission to talk. I asked ASG Rhodes to speak. Want the defendant to be quiet, and is the victim on the line?
Yeah, she's talking.
Okay, then the victim needs to be quiet right now. I've not asked her to speak, and I need her to turn on her camera if I allow her to speak.
Yes, Your Honor. Thank you. My apologies, because I don't know if Your Honor was completely done talking. What I was going to say is, in addition to the stay away, that instead of no further violent contact, the state is asking for no further contact.
That's what I was under the impression.
Yes, Ms. Bridgewater. And I do understand that the victim may have a different opinion, but considering the allegation here, the injuries that the officer observed, the state may very well escalate these charges from simple battery to battery family violence, which are more serious. And the fact that she was pregnant at the time, police did have to be called. And we do have cause for concern, and we do believe there needs to be a cool down period. Thank you, Judge.
All right, thank you. And I'm sorry, I probably meant to say no further contact instead of no further violent. And the victim, if she's on here, turn on your camera, please, ma'am.
Yeah, and we were requesting a no further violent contact, Your Honor, especially based on what Ms. Wilson says, but I think she can speak.
I can't turn on my camera.
Then I can't speak to you.
No, it won't let me turn it on.
Well, that means you signed in without.
Oh no, it's on there.
All right, raise your right hand for me. Do you affirm the testimony you're about to give is the truth, nothing but the truth, under the penalty of perjury?
Yes, ma'am.
All right. Are you in fear of Mr. Faust?
No, ma'am.
You want to have any further contact with him?
Yes, ma'am.
And you're pregnant right now?
Yes, ma'am.
And you were pregnant when the incident happened?
Yes, ma'am. But nothing was physical. It wasn't anything physical that happened.
Did you call the police?
No, he did. He called the police. And because he was just the aggressor in the situation when the police got here, that's why it escalated. It was never me and him got physical. He never put his hands on me.
Okay. All right. Well, my ruling, and I just wanted to give you that opportunity to speak because I didn't know you were on the line. But it's a $2,500 surety bond. I'm still going to order the stay away for the cooling down period. And so he and his attorney can apply for a modification of that bond condition. I will allow, if he gets out on bond, one-time police escort to return to the property to get any personal belongings that he might need while he's out of the home on bond. No further contact with you, and no drugs, alcohol, weapons, or guns while on bond.
But what about the doctor's appointment and stuff? Like,
She'll have to figure out how to make them there by herself right now. I'm going to make sure it's a cooling down period, that there will not be any more escalations for someone to get hurt any more serious than they were. So that is going to be the order of the court so that the two of you can cool down. This has happened less than 24 hours, probably. This is 26 CR 0000363H with Charles Crate, charged with 1 count of battery, family violence, 1 count of simple violence. Simple battery. Pre-trial.
Sorry, I'm on mute. Judge, in regards to Mr. Crape, 8 Cycles, Illinois, 14, Missouri. He has a hold for an FTA out of Vienna, Illinois. I'm 24. He has a simple battery, family violence arrest, 12-225 out of South Fulton, but he was not booked in here. Let me see something real quick, Judge, because I looked at it earlier because I thought these would be on. Somebody must have put it in wrong because our pretrial report says ag assault. Yeah, it says ag assault not resulting in serious bodily injury is what the pre-file was.
You have anything different, ASG Rhodes?
No, I am showing and it's showing 2 counts of the ag assault, but not serious bodily injury as well. So I was somewhat confused by it. What I do have is that, and I don't know if pretrial has this, that the defendant went to jail on November 30th, but he got out on December 2nd for the same victim. And maybe that was the South Fulton case you were talking about earlier, but he was just in, November 30th. But I am showing 2 counts of aggravated assault, but it does says no serious bodily injury. Judge,
you can go ahead. Anything else pretrial that's about what you have is right?
Yes, Judge. Okay. This is a different charge. Great.
Oh.
No, because they don't have the cases linked. Oh, here it is. It's an open 25 CR 007716E.
Okay.
And he has actually got a signature bond on that case by, who gave it to him? Judge Law.
All right. Okay. Thank you. Go ahead, ASG Wells.
Yes, Your Honor. This was January 16th issue at Delano Road. Officers did meet with the victim in that case. In this case, Ms. Tashasha Smith, who was standing outside of her building when they actually came. And she stated that her boyfriend, who was the defendant, was still inside of the apartment. When officers did enter the apartment, they could hear him saying to her, call the police, call the police. And they identified him as Mr. Charles Crape. There was another witness inside of the residence as well, a Miss Smoot. She was seated in the living room. Ms. Smith did advise that she had been asleep all day on the couch and that Mr. Crape woke her up by yelling at her. She stated that Mr. Crape had been drinking, and she advised that when she went to her daughter's bedroom to try to avoid any further confrontation with him, he then followed her yelling and screaming through the door. She began packing a suitcase for an upcoming trip. And Mr. Crape grabbed the suitcase from her, threw those items out of the apartment. When she retrieved them, he emptied the belongings from the suitcase and assaulted her. And I think that this was all because there was some accusations of infidelity that I just don't necessarily think is appropriate to go into. Essentially, Your Honor, what I would say about Mr. Crape is that this is a battery family violence. Since he has been in the jail, he has called the victim in this case, and the victim in this case pretty much during those calls said that she did not want contact with him. The calls were tantamount to influencing the victim, in this case, Ms. Tashasha Smith. As I said before, the defendant just went to jail November 30th and got out on December 2nd for abusing the same victim. And Your Honor, that was a family violence case in December of 2025 as well. I believe pretrial gave you the number. That was 25 CR 007716E. We will be filing a motion to revoke bond on that. I've already filed that motion. That bond motion had in it a condition that he has no further contact with the same victim, Mr. Shasta Smith. And it also had in that bond order that he stay away from the same incident location, which was the Delano Road apartment in number South Fulton. And that's where this incident actually took place. So in addition to him continuing with violent tendencies, he has no regard for the court's authority, as he has violated a direct bond order that told him to have no further contact with this victim and to stay away from that incident location. And as pretrial indicated, there's a 26 PF 000515 case, 2 counts of aggravated assault, but it does say no violent, no serious bodily injury in those aggravated assaults. As such, Your Honor, the state is concerned for the safety of Mr. Shasha Smith, the violent tendencies of Mr. Crape is alarming. We are asking for a cash bond so that he is not able to go through a bonding company in the amount of $20,000 that he would have to post through the jail. We're asking that he has no further contact with to finally have no further contact with Ms. Tashasha Smith. Perhaps if he can't follow court orders, if he's in the jail, he'd be forced to. And that he stay away from the incident location of Delano Road in South Fulton, Georgia. Your Honor, we're asking that he undergoes alcohol drug evaluation and treatment. The victim in this case did state, and it looks like Ms. Smith is on the line, that alcohol was involved in this particular incident. The witness in this case stated that he threw water on her during this incident. It just seems like thing after thing after thing between these two. And Your Honor, we believe that a serious enough bond for him to get the message is in order in this case. Thank you, Judge.
All right.
Yes, Your Honor. Thank you. First of all, Mr. Craig does come before the court with the presumption of innocence. He does deny that there was any physical contact or that he caused any injury with the alleged victim here. He has been in Georgia for over 5 years. I'm advised that he works full-time as a supervisor with a property management company. He indicates that he and the alleged victim are ending their relationship, that he intends to have no further contact with her. Based on all of that, I would ask for a $1,500 good bond, $1,000 on the battery, and $500 on the simple battery, and nothing further from defense, Your Honor.
Okay. And this.
Your Honor, and I would just reiterate to the court, my apologies, but that in addition to the previous violations of the bond order, the state does have jail calls where he's continuously contacting her. So the state does have no confidence that he won't continue.
Okay.
I'm not aware of any of that, Your Honor. I don't have access to that, so I don't know about that.
To the jail calls. All right. So it's the state is recommending $2,000 surety bond. Is that right, Mr. Rhodes?
I'm sorry, Your Honor. We were asking for a $20,000 cash bond, considering the open case that he has with the same victim, the potentiality of the aggravated assault counts that are in Superior Court, and the blatant disregard of the violation of the bond order and his criminal history as recited by pretrial services. We believe that a significant bond is in order. So we're asking for $20,000 cash, Your Honor, but it is based on good reason.
Mm-hmm.
Well, the purpose of the bond, Your Honor, is to assure his appearance in court. I think the amount we asked for, $1,500, would be sufficient to do that.
Well, Your Honor, I also think that the purpose of bond is also to protect victims that can't protect themselves. And in this situation, also, the state may very well consider whether or not there are any other charges as it relates to him. We are going to file the motion to revoke his bond in his current case, where he is just blatantly violated.
Right. How much is that bond, do you know?
Yes, Your Honor.
I think it's 3 or 4. I just looked.
3,000 or 4,000.
Yes,
I have it right here, Your Honor. It is a total of 4,000. Yeah, that is correct. Thank you, Madam. I believe it was Madam Pretrial, or was that Ms. Smith? But it was 4,000. 4,000 split bond, Your Honor. In that bond, he was to have level 2 supervision through pretrial services on the split bond. But it was a $4,000 split bond. If Your Honor is inclined, I would ask that Your Honor revoke that bond and to make.
Your Honor, that requires notice in a separate hearing.
Mm-hmm. Yeah, I can't revoke it, but yes, that will. You all will have to file and have that done. That was a pretrial split.
Yes, Your Honor.
Yeah, pretrial will do a revocation on that. But I will order a $10,000 cash bond. I do the number of cases and the open case are alarming with the same victim. So it'll be a $10,000 cash bond. And even Judge Law even gave him a signature bond. So
Your Honor, is that 5 on each count?
yes. And then stay away from the 4900 Delano Road. No further contact with the victim, to Sasha Smith. No drugs, alcohol, weapons, or guns while on bond.
That's Ms. Smith.
Is it?
Yes, I believe so.
Okay. All right.
Okay, good luck, Mr. Craig.
Your Honor, I don't think we have addressed position 23, Cassie Barner.
I have not had any. That was the one I called the jail multiple times because it's at a different jail location.
Hello?
I
Yes,
have not
hi.
had any contact with Mr. Barner.
Hold on, Ms. Bonner. Hold on, please.
Okay.
Do not speak. So we haven't had any contact?
No, he was at South Annex, and I called South Annex multiple times and was never able to speak to anyone.
Well, well, it's a Saturday, but okay. So 23 will be reset till Monday. That's actually more of a question. Yes, Mr.
Is he not
Jordan.
like? Are they not present or?
We reset some Monday because we can't get in contact with South Annex.
Right.
I mean, would that reset go against him or who would it? Because I don't really want him to be penalized because the jail isn't.
But what else can we do?
Mr. Bartels, what are your thoughts?
Are we talking about 23, Mr. Varner?
Yes,
Yeah.
South Annex is not on the line and they never answered the phone when I tried to call him.
So how do people from South Annex appear before this calendar?
We've had them on before, like ACDC or any other. They get on, but I don't know how people reach them. I thought the jail would know.
They gave me a phone number. They just never answered me. They might answer if the
Deputy in courtroom 2, can you call South Annex?
Yeah, we still have a couple of cases to do on this calendar.
There's nobody's picking up over there. We've tried several times.
Miss Varner?
Yes, ma'am. My son just called me on the phone. He said the phone systems was down over there, and that was the reason why nobody could reach him, and that's the reason why he missed his court date. I just got off the phone with him within 5 minutes.
Well, how did he call you? Should I not ask that question?
He called me through the security system, and I just talked to him 5 minutes ago. He said the phone systems just got up. They've been down over there ever since, I guess, yesterday.
Oh, okay.
How long has he been in?
He been in there ever since the 14th.
So.
And he was supposed to went to court yesterday, and they didn't transfer him to Rice Street. And then they said he was supposed to be in today, and he still didn't get transferred because of the phone system.
Well, it sounds like it's going to be a Riverside.
It sounds like it'll be a Riverside issue. The arrest was the 14th at 5:45 p.m.
Yeah, that's going to be a Riverside issue.
Yeah, I'd agree that it would be Riverside. The jail had given us erroneous information about him being addressed on yesterday. It looks like there might have been some probation violation issues from other cases outside of this case, from what I saw.
Mm-hmm.
And there is no probation violation in Odyssey that's showing up.
Ms. Rossi, is anything else holding him in jail?
No, just this. It's no bond on this case.
Stand by, Judge. Let me see if we can.
Okay.
Your Honor, what if I waive his presence and we just go forward with testimony from his mom and his sister? Because the sister is the victim of the case.
Okay, we have the sister and the mom.
Sister and mom, yeah. Okay. And I'll submit, I'll write that up and email it to Mr. Jordan.
Okay.
Because I think I'd be fine with the court just hearing from them. I talked to sister, she wants him home and is not afraid of him. Mom says she looked and there was no gun.
All right, this is 26 CR 000316G. And his name is Cassie Varner. Okay. Pre-trial?
No prior arrest history. If you choose to release him, pretrial recommends level 1, nothing further.
Okay.
Your Honor, do you want to hear the facts of the case?
Please.
Okay, on January 14th of this year, Officer Smith responded to McWilliams Road, Southeast Atlanta, Georgia, and spoke with Ms. Raven Bardner, who stated that she had a verbal argument with her brother, the defendant, Cassie Bardner. At some point during the argument, the defendant retrieved a firearm, which she described as being a black firearm, and threatened to shoot her. The defendant was inside his bedroom when the officers arrived. Sergeant Holloway issued multiple verbal commands for the defendant to exit the room, which he failed to obey. Officers then made entry into the room, and the defendant again failed to comply with the verbal commands to get on the ground, and he was subsequently taken to the ground by officers without injury. The mother, later identified as Miss Ashley Bardner, arrived on scene and provided video footage from an interior home camera. The video contained audio and showed Cassie holding a firearm while stating that he was going to pop the victim. Although there is no criminal history, these are serious charges involving a firearm. The state's recommendation is a $3,000 surety bond, $2,000 for the terroristic threats and acts, $1,000 for the willful obstruction, no further violent contact with the sister and victim, Raven Bardner, no alcohol, drugs, or weapons while on bond, and to surrender any firearms.
Yeah. And then I spoke with the mom and the sister. Mom said that there was no gun on video. There wasn't a gun in the house. But I would ask that the court talk to mom and sister. I spoke to sister. They both live with mom. He's in the 11th grade, has never been in trouble before. Sister's not afraid of him, wants him to come home. I would ask for a signature bond, no violent contact, and that he stay in school. But I would ask that the court ask mom and sister any questions.
All right. Unmute yourself, Ms. Varner.
Hello, hey ma'am. How you
Hi,
doing?
I'm good. How are you?
Good. How are you doing?
How old are you?
I'm 21.
Oh, 21. All right. Raise your right hand. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right. Put your hand down for me. So you're stating that the officers did not see a gun?
Yes, they didn't find a gun. Actually, it was just the heat of the argument. I had mistaken the gun. It was really just his phone case and the flashlight. I just seen the flashlight, so that's why I thought it was a gun. And he said he was going to pop, but those were like fighting words. It was just the heat of the argument what made everything get out of context. I just needed a mediator to come and mediate the issues so we can stop arguing. It was only us two in the house, so I just needed somebody to calm down the problem. And I thought he had it, but he did not have a gun.
So you called the police?
Yes.
What kind of student is he?
He goes to Maynard Jackson.
Does he have good grades, average grades, or what?
Good grades, AB honor roll student.
Can the host let South Annex in?
I'm sorry?
Somebody let.
They're on. South Fulton is on. I think his attorney was doing a waiver, but if they're on.
If they're on, I actually just sent it, but.
Oh, I see it. He's on now.
Casey on here. Oh, she's trying to talk to you.
Based on testimony from sister, I again would ask for and his mother, I would ask for a signature bond with whatever conditions the court asks for with the no violent contact so that he can go home. There was no gun involved.
Your Honor, there is no way. The report says that there is video. And I would like to ask Ms. Varner if
we showed the video during. I'm sorry.
Hold on, don't cut her off. Hold on.
Yes,
I'm sorry.
Yes, Ms. Varner. So what made you think that a flashlight was a gun? A gun doesn't have a flashlight.
Yeah, some guns do have a flashlight, and I seen the reflection just on the ground. I just seen the flashlight, so I thought it was a gun, but it wasn't. It was just his phone he had under his hand in a black case. I just mistaken.
And so
it was just the heated argument that made me think it was that. But me and my brother,
And the fact that you stated, and it says in the record that he said he was gonna pop you.
Yeah, that's what he said, pop. But those are fighting words. We were just arguing. It's just a sibling argument. But he wasn't meaning like gun violence. He didn't even have a gun to pop me.
So again, my question, Ms. Varner, is how can you confuse a phone with a firearm? And how are you so familiar with firearms that you know that some firearms do have flashlights?
We own firearms, and I mean, my mama owns like 4 guns, so I know a lot about firearms. I know that it can be different accessories put on it. So I thought that he had that, but he didn't. He doesn't even own a gun.
Well, the problem I'm having now is you have firearms in the house. You and your brother have beef a little bit, and you all need to
we don't
down. This happened. Hold on, don't cut me off.
Sorry.
This happened a few days ago.
Yes.
I don't know if it's cooled down. Maybe your brother is cooling down because he's been sitting in jail, but I want all the guns removed from the house.
It was my understanding that the guns were not in the house.
Okay. That's not no problem.
She just said they were. Where the guns gonna be? Her mother owns 4 of them. They're in the house.
Hey, how you doing?
Hold on. I'm not speaking to you at the moment.
Oh, okay.
I'm talking. All right. So you all listen to me. And here's what I do as the judge. I sit back and I listen to people. And if I let them talk, they'll usually tell me what I want to hear. May not be what I'd like to hear, but what I need to hear. And what I'm understanding, your daughter is very familiar. I mean, she's 21, she's grown, and you all have a right to have these guns for hopefully just protection. But my concern is when they're in the house, and we're hearing cases a lot on the news with kids shooting themselves, getting a hold of parents' guns. I hope you all have a gun and have those guns properly stored and have a gun cabinet and have some safeties and this, that, the other. And, I see the defendant shaking his head. So he must be familiar with guns. And when you have them around and available, sometimes when you're arguing, people are going to threaten them because they know where to go get them. Yeah. And they have them in their possession. And that's what I'm afraid of. That's what's scaring me. That's what I hear. And it could be an accident. And we could be here on a totally different matter. Okay?
Okay. May I speak, Your Honor?
Now that I'm done, you can speak.
Okay, thank you so much. The firearms are locked away in the code that my mom only knows. She does not tell them to us. I don't even know the codes to the firearm. Only she knows them. So even if we probably were in trouble at the house, we would just be having to call the police because we couldn't get a gun.
Mm-hmm.
We don't know she has them like locked away in a safe, but we don't know the code to the safe. No way to open them.
So, Ms. Varner, if that's the case, what made you think that your brother was holding a gun and not just his cell phone?
Yeah, because he was just walking. It was just this heated argument. I was standing in the corner and I just took a quick glance at him and I seen a flashlight. I thought the flashlight was a gun. And I was like, oh, because we were saying the fight. We were just arguing, saying words and stuff to each other. So that's why I was thinking that he was going to do that. But I know my brother would never do it. It's just that I was just trying to call the police to get somebody to mediate the argument. And if he did have one, but when they came to the scene, it wasn't nothing there. So the whole time I was like, I was mistaken.
And the police have in their report. Can you quote me and read in the report with Melgioso to tell me what the report says exactly?
Yes, me?
Hold on. No, Ms. Varner. I'm asking the ASG, the prosecutor, to read to me what the police report says.
Absolutely. Okay. Do you want me to read the entire report or just
maybe not the entire, but that part?
Okay, give me just one moment and I'll pull it up.
And who did the video come from? Them or the officers? Or is it from its body cam?
It was them. It was video from an interior home camera. The video contained audio and showed Cassie holding a firearm while stating that he was going to pop the victim.
And that's what the police report says. They got it from their internal
Yes, Your Honor.
video. It shows him holding a gun. That's what the police report says. So you're telling me the police report is wrong?
That is what his mom told me. That she looked at the video and that there was no gun in the video.
Who looked at the video?
The mom. She said she still has the video.
Have you looked at the video, Ms. Bronstein?
I just talked to them for 2 seconds before I was able to get back in front of the court, and I had still not talked to him. Again, I was trying to call all day to speak to him to sort this all out. So no, I'm relying on what the mom and the sister say. Sister says that she is not afraid of him. He is an 11th grader, just turned 17. And I'm asking that the court take the words of the victim into consideration. They live together. They live with their mom.
I would take the words of the victim into consideration, but as you know, many victims come on and the whole story goes left and it's totally different. And she called the police because she was in fear. Most people don't call the police to be a mediator. They know that could go left. She should have called her mom or her cousin or a friend or something like that. But calling the police is pretty serious. That means you're scared. Generally. That means you're scared of something. I mean, whether it was his words that scared her or not.
I believe she has one more thing to say.
All right, Ms. Varner.
Oh man, I was not in fear of him. I actually had called my mom 3 times prior to calling the police. I did not really want to call the police. Like, if my mom would have came, we would never be here. I just called her I called her first. I was not trying to call the police. I just called the police because that was my last option.
Okay. And your mom was not able to pick up.
Yeah, she was picking up the kids from school. She was gone, and I was trying to ask her where she was at because me and my brother was arguing, and it just escalated to me calling the police. I was being overdramatic. I was on the phone. Yeah, I talked to him on the phone. I was on the phone with my mama and I was on the phone with my friend. I just was trying to call people.
I'm very, very, very concerned. I'll just tell you that.
I'm sorry.
I said I'm very concerned.
Yes, I know.
So do you all go to the gun range together?
I'm sorry. Do we go to the gun range together? No.
Has
My
your
mom
brother
doesn't
ever-
take
has
us.
your-
She just
has
has.
your-
It's really her thing. She likes guns for protection.
Well,
for
it
our
sounds
house,
like
so-
you do too.
Yeah, I
You
just know about
some
them.
can
Like,
have a
if
light.
it's around me, that's just something I know about.
Right. Have you been to the gun range before?
And I don't own a gun.
Has he been to the gun range before? Has he been in the back of the house shooting guns? What's your brother know about guns?
Because our mom, it's just, I wouldn't know. It's just like if something was around us, we would know
But
about
you
it.
know some parents expose their children to guns.
Yeah. But our mom, she just let us, like, we know it's for protection for if somebody come to our house. We got private property signs.
But how
cameras
can you
everywhere.
get to the gun if it's in a gun? If it's in a gun case with a
That's
combination,
why
only
she's
she
home most of
knows.
the time. It's really on her. If she's not home, then we'll have to call the police. She be home most of the time. So it's like it's rare for somebody to come to our house.
Your Honor, the state did request the video evidence. We have not received it yet, so I was not able to review the video, but the state is going to continue to ask for a surety bond based on the statements and the text messages that the defendant is putting on the chat. If at the end of the day, the video shows that there is no gun, then that can be resolved later. But this is a serious charge when you are waving a gun during an argument. And it's a very serious concern. And so, Your Honor, the state is going to still ask for the surety bond.
Bronstein?
They're asking for a surety bond, but he
And Mr. Varner, I don't see anything concerning about his messages, but Mr. Varner, please stop sending them. I would again ask that he be released with whatever conditions. No violent contact, stay in school, whatever the court deems appropriate.
Mm-hmm. Does your brother, does Mr. Varner have a job or anything?
Yes, I work with my mama.
Where?
She own her own cleaning business called Everything Spotless Clean. So we go clean up houses together, and sometimes I move stuff for her too.
What kind of grades do you have, Mr. Varner?
I have A's and B's. I go to Manor Jackson High School. I'm in the second grade.
Say that again. I didn't hear you.
I have A's and B's now.
Well, this is again a very serious charge.
Yeah.
I understand that we have a video. I'm not here to go back over that. And I just honestly, and if we're wrong, we apologize. Don't think officers will put in a report there was a gun when there wasn't, especially with a video, because that could be easily told. That could be easily seen. What are you going to say?
Ma'am, I swear to God, I swear.
You stop talking.
I did not have
No, I know. I have told the judge that.
Oh, Casey, they said you can't talk. Just stop real quick. And we showed the.
Oh, you're on mute now.
All right, I'm going to
I'm sorry, Your Honor. I'm sorry.
Go
The
ahead.
city would like to add that he reports school attendance and his grades as part of the requirements for the bond.
That he reports to what now?
Reports school attendance and grades.
Oh, okay.
And they might need a curfew as well.
Had that in my brain. Thank you. Yes, I did. I always, yeah, thank you. I'm going to make sure, and I'm going to increase the surety bond because I just want to make sure that we don't see Mr. Varner again. And I'm very, very serious about guns or the talk of guns or the use of guns. And that is concerning me. And you can always apply for a modification of the bond conditions if we find out. Of course, the state will find out if it's not true. But right now I have to go with the evidence that I have. And my inclination was to set a $10,000 surety bond because of the gun allegation. The terroristic threats, whether you had a gun or not, threaten to pop somebody or kill somebody is pretty serious. And the obstruction that, with the officers and not following those commands, those are all serious things. And, I want you to learn from it, Mr. Varner, and as we say, never to see you again, not in this setting or situation. But I will make it a $6,000 surety bond. And with that $6,000 surety bond, you are to have no further violent contact with your sister or your mother, for that matter. And I know your sister is the victim in this case. No further violent contact. Allow you to obviously go back home, but the conditions are that you will go to school every day. You will report your school attendance and grades while on bond, and he's given that to his attorney?
Yes, Your Honor. And if
would it be a weekly?
We wouldn't represent him until he applies. So I don't know.
Oh, okay.
Unless you want to do a split bond.
Do a split
pre-trial
bond and report it to pretrial.
Okay, let's do that. Let's do a split bond. And what do you recommend the split be? ASG Road?
Yes, Your Honor. I would recommend that it be a we could keep it at the $6,000 bond total, 4,000 surety, 2,000 signature bond through pretrial services. And if he's going to be going to school level 2, and that while he is on bond, that he report his school attendance and these good grades that he's reported to the court that he's getting, these A's and B's, that he report those to pretrial, that they be reported to pretrial services, and with the understanding that he is fully attending school, and that while on bond, he has a curfew set to where he would. Yeah. Thank you, Judge.
Judge, since he's in school, can you make it level 1?
2 times a month. It should not be that difficult. Is he working some type
It's the in-person part, Mr. Rhodes.
I'm sorry?
It's the in-person part. If he's attending school, he's in school. He would
during
have
the
to be in
day.
school to report.
Let me ask you this. He can't report after 3 o'clock? Is that
possibly, but that would be pushing it. That means
Gotta
this
get
could be setting him up
downtown.
for failure.
2 times a month just seems reasonable to get
It's
down.
not the number of times, it's the in-person part since he's in school.
And pretrial office closes at 5, Ms.
Yep.
Paulson? Judge, I think level 2 is fine, but I'll defer to
And even with the 2 times, if I order that he can call in one time and come in one time, they wouldn't do that.
He doesn't report both times, it's just monthly. But generally, if they're in school, I would prefer not to be in person, so they're not missing school in order to report.
It's 2 times a month, Your Honor, on level 2.
2 times a month on level 2, but one of them is in person.
I believe they're
Is that
both
what I'm
in
hearing?
person, but I believe though you can order it to as one in person and one by way of phone.
I'm pretty sure I can do that pretrial if I put him on a level 2 and
Judge,
one.
that's what it is. It's one time. If it's level 2, it's once monthly in person.
Oh, okay. I think I did
And then you
misunderstood
report weekly by phone.
Got you. Okay. Then I can do level 2 since it's only one time in person. And hopefully he won't have to miss school, or it can hopefully be excused. So I'll put him on level 2. And if you can work with him on the timing, and he can be the last appointment of the day and they can make it downtown. I'd rather have him on a level 2 till we know more. His curfew is going to be from 8:30 p.m. to what time do you get the bus in the morning, Mr. Varner? Are you a car rider?
I'm a car rider. I get to school around, I think, 8:30, or sometimes I get around 8:30. 8:30.
That's late.
Well,
8:30.
That's what time I start school. But I get around school like 8:26, and I'll be in the building by
Okay.
8:20.
What time do you leave in the morning?
What time I leave? I leave so first my mama, she dropped my little sister off because she in middle school. Then she come back and come get us around like 8 o'clock on the dot, and then we be there by 8:15. Then we gotta wait in the line to get us out the building. So I'll be there by like 8:26.
Okay. So 8:30 p.m. You have to be in by 8:30 p.m. and then in the morning.
Okay.
I'm sorry.
Excuse me, Your Honor. I'm sorry. But another thing about it, also my school do late passes too. So if I'm late to school, they'll give me a late pass.
Okay. But we don't want you to be late.
Now that's what I'm saying. I ain't aiming for it to be late.
So I'm going to say 8:30 p.m. to 7:30 a.m. in case you'd have to get picked up earlier just to make sure you get to school on time. So 8:30 p.m. you need to be in the house doing your homework. 7:30 a.m. you can begin to leave the house, or 8 o'clock, whatever time your mom picks you up. But I'm very serious about the curfew. They will call and check on you. Pretrial will, to make sure you're abiding by the curfew. And then we want you to report your school attendance and your grades to pretrial. And I'm going to put on there, Ms. Holly, if pretrial can work with him about the reporting. But if it's once a month in person, I guess it doesn't matter.
I'm sorry, Your Honor, is he in sports or something?
I know. Are you in sports or anything? Good question.
Nah, I'm not
No.
in sport.
8:30 seems
I
late.
I was finna try out for track, but it looked like that's over with.
Mm-hmm. So we can do sometimes I do the same number, 7:30, so people kind of understand the times. So let's change it 7:30 to 7:30. So get you in the house early.
Your Honor, can I ask one more question, ma'am?
One last question.
Would I have a monitor?
No,
Okay.
but that doesn't mean I want you to cheat about it and be at Walmart at 8:00. And when they call you, I think they have a way to tell. I'm not sure. Because they're going to do certain things to make sure you at home at 7:30. Not just with your mom and your sister and everybody. But I don't want to tell their secrets. But 7:30 to 7:30, let's make the times the same. And this is while you're on bond. It's just start some good habits. Anything else, ASG Rhodes?
No, Your Honor. That's
all. I know what else. If you have any guns in your possession, you need to surrender them to the Fulton County Marshal's Department or the Sheriff's Department. And I'm going to require your mother and your sister, if there are any guns in the home, and I understand they are, that they must be at all times locked in a gun cabinet or safe. Because at first I thought about having your mother turn in her guns. And sometimes it's just a breeding ground for some issues. But I won't at this point have your mother to turn her guns in, but they are required to be locked in a gun case, safeties, and you and your sister, neither of you need to have access. The victim or the defendant. There'll be some strong language on that. Neither should have access to those guns. Anything else, Mr. Rhodes, I can think of?
I think that about covers it, Your Honor. Thank you.
All right, thank you. Any questions, PD Brunstein?
No, Your Honor.
Okay. All right, thank you. Good luck to you.
Thank you, Your Honor.
All right, you're welcome.
I think that's it.
Okay, that's it. Thank you, Deputy.
Your Honor, did you receive those other orders?
Oh, I heard the ding, so I apologize.
I'm gonna send you this one, and that should be.
That'll be the rest of them. I was trying to multitask.
Okay. Well, if that's it, you guys have a good one.
You too. Thank you.
Those of you who will be here with me on Monday, I guess I'll see you then, huh?
I will not. Have a good King holiday.
Thank you.
Have a good holiday, everybody.
Yeah.
All right, you
Take
too.
care.
Okay, bye-bye.
Bye. Bye-bye.
But you were here with me on this wonderful Monday edition of the Court Gallery. To answer the question previously asked about the souvenir ankle monitors for fashion purposes, yes, there are actually designer ankle monitors that are, I believe, functional. Not used for police purposes, but they are designer ankle monitors that can be worn specifically for fashion purposes. And why you would ever want such a thing? Don't make this old wolf lie about it. I have no clue. It does not seem like a fun piece of accoutrement to include in a fashionable fit. But ladies and gentlemen, this is all I have got for you today. This is all I put together. Tomorrow, we pick up the regular week of regular court cases. I'm sure we'll have about 2 hours of regular daily court content. Come on by about 8 o'clock, 9 o'clock Eastern Time, 8 o'clock Central Time, 9 o'clock Eastern Time. Same Wolf time, same Wolf channel. I'll be right here with more court than you can shake a stick at. But for the time being, I am your Lone Wolf Oozle. I'm your humble host for these here videos, and that's the puppy. And I am out. Y'all have a great night. And one dark pillar with the shore sote, the drought of March had perished to the rote.